even before the vote later this year on The Voice, we're already a country that treats people differently on race. In so many aspects of public policy, state and federal, that's rarely in the interests of the people impacted. As an example that powerfully highlights this very point, in New South Wales, a judge has just declined to allow the adoption of two little children with some Aboriginal ancestry by foster parents who have cared for them since infancy because, as reported in the Australian newspaper today, under state law, an Aboriginal child can only be adopted by non-Aboriginal people if an adoption within the relevant Aboriginal community or another Aboriginal community isn't feasible. Under the New South Wales Adoption Act, non-Aboriginal parents adopting Aboriginal children have to do so in consultation with a person nominated by their blood relatives and recognised by the relevant community. So connected to the very parents that have either relinquished the child or had the child removed from them and put into care for the child's protection. Under New South Wales law, the local Aboriginal organisation also has to be consulted. They have to get a say. As it happens in this case, one Aboriginal organisation declared that it doesn't support any adoption and another was failed to respond. According to media reports, the mother of the children says she does not want them placed with a non-Aboriginal family. And so now this case before the New South Wales Supreme Court is there for the judge to decide which way it goes. All children need parents, preferably parents who'll stay involved with them for their whole life. And that applies regardless of the colour of their skin or that of their carers. In this case, the judge said that it was abundantly in the best interests of the children to stay with their current foster parents, who, as I said, would like to adopt them, and noted that the foster parents were already doing their best to familiarise the children with Aboriginal culture. It's worth noting here, in this case too, the Aboriginal heritage of the two children only came to light years after they were put with their current would-be adoptive parents. As Justice James Stevenson said, the relevant provisions of the Adoption Act appear to have been drafted on the assumption that a child's Aboriginality will be detected at an early stage and before the child is placed with persons who ultimately seek to adopt the child. As this case demonstrates, said the judge, this does not always occur. Now, in this case, this apparent inability to act in consultation with an Indigenous body is a tragedy for this family. And while the matter, as I said, is before the courts, it doesn't take much to see this sort of legal obstacle play out at a national level if the voice gets up. Imagine the delays to decision-making if anything that impacts on Aboriginal people and what doesn't impact on them needs the approval of the voice or even consultation with the voice in order to proceed. Now, Australians, be careful, you will reap what you sow.